Okay. Hello, everyone, and good morning or afternoon or evening, wherever you are. Thank you for joining us for a webinar on new approaches to tackle wiretapping litigation risk with Matt Pearson from Frankfurt Kurnit and our own James Ensor. Before we start introductions, I want to mention just a few housekeeping items. We are recording today's session, and the recording will be made available on demand later this week. So you should receive an email once the recording is available to the email address that you used to register. We also have a questions tab that is in your bottom right-hand corner. So please feel free to drop your questions there, and we'll aim to answer as many of those questions as time allows towards the end of today's webinar. Please try to use the questions tab instead of the chat tab. We'll try to monitor both, but we're more likely to see it and answer your question if it's in that questions tab. So I think that covers all housekeeping items so far. So let's dive in. Let's start with quick introductions. I'm Julie Rubash. I'm the General Counsel and Chief Privacy Officer for Sourcepoint by Didomi. I provide internal support for our products on both the Didomi side and the Sourcepoint side. I will turn it over to my co-panelists to introduce themselves. Matt?
Thanks, Julie. I'm Matt Pearson. I'm a partner at Frankfurt, Kurnit, Klein, and Selz. I'm a class action litigator. I'm in California. So the combination of those two means I am a privacy class action litigator, probably for the last 10 years, and the last 2 years very focused on probably what most people are focused on, and that is wiretapping. It's probably why you're here. And yeah, I'm excited to be here, talk about wiretapping and some potential mitigation steps. James, I'll turn it over to you.
Cool, thanks very much, Matt. Yeah, hi everybody, good to meet you. My name's James. I'm the head of sales at Addingwell. I work with brands to support them on moving to server-side tagging and tracking infrastructure. So yeah, exciting topic. Looking forward to talking about it with the guys today.
Okay, with that, I will turn it over to Matt to get started.
Sure. So I'm sure everybody's somewhat aware, but the agenda today, we're going to talk about, and I will start with a pretty high-level overview of what these claims are, why we're seeing them now, what plaintiffs' counsel are alleging, where we see the biggest exposure and the like. So basically just kind of the maybe a little bit higher than the 101 level of, hey, this is what you're dealing with. This is when you get a demand letter, when you get a complaint, this is what it's based on. After that, Julie will jump into some regulatory actions, right? There are two sides of this coin, one being the litigation side, which is what I mostly focus on. The other side is, state AGs, specifically California AG, doing investigations, making waves, making news with, ever increasing penalties and injunctive relief and other sweeps. And then James will jump on and do his best to explain to me in very simple language what server-side tracking is, what it means, and we're going to do that as kind of a question and answer approach, because when James and I first got on the call, I asked probably all of the questions you guys would have, and especially from my perspective, being a lawyer and not super technical, we're just going to kind of walk through that process. Just to kind of reiterate what Julie said, if you guys do have questions, just drop them in that question tab down at the bottom right. We'll probably hold on to them until the end, and if we have extra time, we'll jump into them. But to the extent we see anything or we think we need to address something, it's great to have them there, and maybe we can do it on the way.
And actually, I forgot before you jump into your content, we do have a poll to share just to get an idea of get to know you a little better, get to know our audience a little better.
And that's in the polls tab at the bottom right.
Yes, that is in the polls tab in the bottom right.
Okay. Well, I'm seeing these come in real time, and we are very concerned. Which I'll admit, having dealt with this and dealing with this on a daily basis, I think it's a rational concern. So let's talk about what it is that's actually being litigated, what's being alleged. So that there are a bunch of variations, and we'll talk about it, but there are a bunch of variations of the claims being asserted and the like, but ultimately, they really all do boil down to the same basic technology doing the same basic thing. And what I mean by that is plaintiff's theory across the board is that there's some surreptitious, right? We could all kind of quibble with whether or not it's actually surreptitious, but the allegation is that there's some surreptitious collection of information about a website visitor. The way we normally see this, and it really does vary based on the clients that we're dealing with, but the way that we normally see it is, and I'll use the most simple example, some analytics pixel running on your website, collecting information like who's on your site, not even who, but where the people visiting your site are from, what they're doing on your site, button clicks, the like. I mean, that is at its most simple, but that kind of evolves the more, or just based on different clients, but ultimately that's what it comes down to: tracking of visitors to specific websites. Obviously, the website at issue is going to have an impact. Obviously, what information is being collected by the technology is going to have an impact. Can you guys still hear me?
Yes.
Oh, sorry. My whole thing is shut down, but I can talk through anything. It's basically the same technology, and it is evolving over time. When we first started seeing these claims, I mean, very, very early on, we were talking about chatbots, and then we moved to session replay. Then we went more into the pixels, the tags. Now we're seeing more SDK claims. We're seeing it move towards apps, but it ultimately does kind of all boil down to similar technology, similar operations. I get this question all the time, and it's like, what the heck are they even alleging? Like, what is even going on, and how do they know? So this is just an example. I hopefully have blurred out anything that would identify anybody, but this is basically what a plaintiff's counsel does on a website. Goes onto a website, right-click, inspect, and sees all of the network traffic. And so I have highlighted Google Analytics because it's basically ubiquitous, right? Everybody's using Google Analytics. But what this is really intended to show is, to the extent you guys are coming in and saying, we don't collect a ton of information, we don't collect any information or anything like that, there actually is a lot of information that is being collected. Now, granted, it's not the information where we would normally look at it and go, oh my gosh, that's so sensitive. But it is a good amount of information, and it's information that's used to, in most instances, really kind of narrow down who it is that's on the website. Now, I'm not going to say that it's, hey, this is Matt Pearson on the website. But if you look at this, I mean, you can see what browser I'm using, what screen size, my IP address is necessarily transferred, operating system, all of those additional data points, especially from plaintiff's counsel's perspective, narrows and narrows and narrows and gets closer and closer to identification, even though I don't think we really are getting there. It also includes unique cookie values, the URL that you're on, or could include the URL you're on, also the URL you came for, the referrer header. So a good amount of information there. Okay, so why now, right? Like 3 years ago, we weren't dealing with this, and CIPA's been around since 1967, and the pen register trap and trace part of it's been around since 2015. Why are we seeing this surge now? It comes down to two things. Well, three things, I would say. Statutory damages, right? And for those of you who don't know, statutory damages are damages associated with the specific violation of the statute that require really no injury on the part of the plaintiff. So basically, if I show up on your website and I say, you violated CIPA, you violated my rights under CIPA, I'm entitled to $5,000. And you can imagine somebody coming or running even a website with pretty minimal traffic, like 100 unique visitors per day. And let's just say there's only one alleged tracker on there. It's a 365-day statute of limitations. So 5,000 times 100 times 365, those numbers add up really, really quickly. On top of that, I think the knowledge within the plaintiff's bar has increased significantly as to what companies are doing tech-wise, and also the ubiquity of it. It is very easy to add these things to a website. I say that I've never done it myself, but I've been told it is easy to do. And you know, the more and more companies are doing it, the more opportunities there are for lawsuits. And so that's kind of the lay of the land. I will tell you that, like most things privacy litigation related, it is a moving target, and it is constantly evolving. For example, like I described in the beginning, it evolved through technologies. It's also evolving through claims. We started with the CIPA 631 wiretap. Actually started with a 632 unlawful recording. Then it went to 631 wiretap, 638.51 pen register trap and trace. Now we're seeing these CIDAFA claims. And I don't know if anybody's read the CIDAFA statute, but I've read it many times. It doesn't get any clearer. We've seen VPPA claims, but you know, the thing to keep in mind is regardless of which claim is really being asserted, it's the same basic technology that these plaintiffs' counsel are focusing on.
Thank you, Matt. So now that Matt gave you an updated overview of the litigation landscape, I want to talk about risk mitigation tactics, which is the reason we're here. Now, I'll tell you right off the bat that there is no silver bullet here, and that removing tracking technologies, other than removing tracking technologies altogether from your properties, which may not be a realistic option for a lot of companies, you're going to have to, weigh the factors and make some compromises. But what can you do? Well, one option is to seek consent. But if you decide to take that route, you have to think very carefully about how you do it, because you can actually expose yourself to increased risk, both from a litigation perspective and from a regulatory perspective if you don't implement it correctly. So I'll talk about some of the regulatory cases real quick, and then we'll get into some of the other risk factors as well as some other mitigation tactics. The dangerous instinct many companies adopt is that opt-in consent in any form is more compliant than opt-out. So if they think we're seeking opt-in consent, we can throw all other state regulatory requirements out the window. This leads companies to carelessly put cookie banners up that aren't based on the laws they're trying to address, aren't tied to their actual data practices, and don't work together with other privacy choices. Such as, opt-out mechanisms that they have to put in place to comply with state privacy laws. As a result, they open themselves up to more litigation exposure for deceptive practices and to regulatory exposure for failure to comply with the requirements under those state privacy laws. And we've seen several examples of regulatory enforcement against broken, deceptive, or non-compliant consent banners in the US. So I'll go through a few of those examples. So first, in Cal Privacy's case against Honda, Honda had a cookie management tool that looked like this. The user was opted into the various cookie options by default, but they could adjust the toggles and then click confirm my choices to turn them off. Then if they returned to the cookie management tool later, an allow all button appeared at the top that allowed the users to opt back in with just one click. They also use a cookie management tool to obtain opt-in consent in some circumstances, and the consent allowed users to accept all cookies with one click, but required users to use at least 2 clicks to opt out. The problem in both of these circumstances was that, according to the settlement, the path to exercise a more privacy protective option took longer or required more steps than the path to exercise a less privacy protective option. So there was no symmetry of choice, which is required by the CCPA. So the takeaway here is that if you choose to have users opted in by default, the process for opting out can't be more difficult than the process for opting back in. And conversely, if you choose to ask users to opt in, for example, through a cookie banner, the process of opting out must be as easy to exercise as the process for opting in. So for example, if you have an accept all button, you should also have a reject all or a decline all button. The California AG entered into a settlement with Healthline Media, which publishes the website healthline.com. Among other allegations, the AG asserted that Healthline failed to allow consumers to opt out of the sharing of personal information for targeted advertising. In this case, Healthline offered a cookie banner that required users to click more information, as you can see here, and then uncheck the allow button to opt out. And even if the user did that, the banner didn't actually work to disable cookies. So once again, we have some symmetry of choice issues here, but the more important takeaway is to ensure that any mechanisms you're offering to users actually work as promised. Cal Privacy's case against Play on Sports alleged that the high school ticketing and events platform forced users to agree to tracking technologies used for targeted advertising without recognizing opt-out preference signals or providing a sufficient way to opt out. The website included the banners shown here, asking users to click agree to accept the use of tracking technologies and the website's terms before proceeding, but it didn't offer any option other than agreement. The website also included a Your Privacy Choices link that directed users to a toll-free number and email address to opt out of the sale or sharing of personal information, but these methods didn't opt users out of the sale of information used for third-party tracking technologies. So this is probably the best example showing that having a consent banner isn't a valid replacement for meeting the CCPA's specific requirements. You still have to recognize opt-out preference signals and provide users with an option available through a link, a do not sell or share my personal information or Your Privacy Choices link, to exhaustively opt users out of the sale or sharing of personal information, whether occurring via tracking technologies or otherwise. And if you choose to seek opt-in consent to use or sell personal information, consumers must be given an equal and symmetrical choice to opt out, we talked about earlier. Okay, and then finally, the California AG settled with Sling TV over allegations that the streaming service violated the CCPA and California's unfair competition law, in part because it confusingly combined the CCPA opt-out with cookie choices. Now, this one doesn't involve the company seeking opt-in consent in any form, but the takeaways here are still relevant. Sling TV offered 2 separate privacy mechanisms. One is a cookie preference controls available behind a Your Privacy Choices link on its website, and the other was a separate web form available behind allegedly harder to find text embedded links that users could complete to opt out of the sale or sharing of personal information. According to the complaint, the cookie preference controls only stop certain cookies and tracking technologies. and only on that specific browser used to access Sling TV's website, which had no effect on Sling TV continuing to sell or share the consumer's personal information when consumers returned to watch Sling TV on their living room device via the Sling TV app. Users could only direct Sling TV to stop all non-cookie based selling and sharing of their personal information across browsers, devices, and offline by completing the web form. So the combination of both methods allegedly caused added confusion because, and I quote from the case, consumers had to realize that rejecting cookies was not the same as submitting a CCPA opt-out, and then had to locate a link embedded in text that directed them to a separate opt-out page. So the takeaway here is that if you have separate mechanisms for tracking technologies and the broader sale and share of personal information, make sure it's clear to the user and doesn't create added confusion. Okay, so let's bring it back to the core topic of this webinar, which is how to mitigate wiretapping litigation risk. And I think we have another poll at this point. Yes. So which of the following measures has your organization already implemented to mitigate pixel-related litigation risk? And we'll give you a minute to submit your vote there. And while you're doing that, I'll turn it over to Matt to talk about what are some, I talked about inherent conflicts with California law. What are some other conflicts that can arise with respect to this tracking litigation?
Sure. So, I think it's really important to highlight and explain that what I was talking about in the first section was all California Invasion of Privacy Act, right? CIPA. What Julie was talking about was the CCPA, right? The enforcement actions come under the CCPA. We haven't seen any enforcement actions under CIPA. I don't expect we'll see anytime soon. So we have two different laws being used by two different parties, plaintiffs' counsel and state AGs, to regulate basically the same thing. CCPA is much broader, but that's the issue that we're dealing with. And so when I get calls from clients and they say, well, how can I get a CIPA demand letter, or why am I being sued? I'm CCPA compliant. I say, that's great, but it doesn't help you necessarily with regard to CIPA. And the reason that is because the CCPA creates what we call an opt-out regime, which means you have to give people the ability to say, don't do this. CIPA has been interpreted to require prior consent. So now what you're dealing with is two laws, two different standards regulating the same conduct. And it's very confusing to clients. And in fact, when I have these conversations with clients, I generally try, at least initially, to draw a distinction between the two. CCPA, which I call compliance, and CIPA, which is litigation, right? Try to draw a distinction between the two because they do require two different things. And ultimately, what we try to do is harmonize them after we've kind of separated them in the way that we think about it. So one big issue and one reason driving all of this litigation is the statute that everybody thought applied, and it does apply, requires something different than the statute being leveraged by plaintiffs' counsel to bring all these lawsuits. So that's inconsistency number one. The other inconsistency I get is, everybody sees cookie banners and they say, well, we got to disclose. But everybody's marketing team is like, please stop making it harder for people to get to the website, right? They don't need 19 pop-ups and all this stuff. So it's balancing friction on the website plus necessary legal disclosures to protect. Then the same thing happens with advertising, right? Julie talked about hey, the way you can immunize yourself from this lawsuit is just don't do this. That's not really an option, right? Like I've had this conversation with so many clients where they say, we don't want to deal with this anymore. And I say, okay, take this off the website. And they're like, okay, no. And I say, okay, well, then you've got to find the middle ground. You've got to thread the needle. So it is balancing the efficiency and the effectiveness of your digital advertising with litigation exposure. And then another one is in my world, certainty benefits me, right? If I knew that what was happening violated the law, I could tell a client, do not do this. But that is not where we are in this world. There is a writ petition going on right now to decide whether or not the pen register trap and trace provision even applies to the internet. There is a Supreme Court decision with regard to the VPPA, with regard to the ECPA. Courts are all over the map as to the crime tort exception. And so there's a ton of uncertainty. And my clients are like, just tell me what to do. And I say, well, no, it's not that simple, because we don't necessarily know how this law is going to be applied to what and in what states. So that's another kind of friction point. And ultimately what it does boil down to is you have a conflict between legal, marketing, and IT. And legal might have a very different priority than marketing would, than IT would. They speak different languages. So really it is a conflict among the three that needs to be harmonized. In fact, if there was a theme to this presentation, it would be trying to harmonize things that are inherently contradict. So that is kind of the goal with all of this. And go ahead, Julie.
Yeah, so if you get consent and looking at the poll results, it looks like 29% of you are getting consent, but that we have a good mix of various different strategies right now, which makes sense given all the conflicts that Matt talked about. But if you do see consent, it's really important that you think about it carefully and holistically. Consider how consent works together with your opt-out mechanisms. Ensure disclosures are clear and reflect actual practices. Ensure tracking technologies don't fire unless and until a user consents. This one is a really important, both for regulatory and for the litigation mitigation itself. The mitigation isn't going to work if this one isn't working correctly. So this is a really important one. Offer symmetry and choice. As I talked about, opting out should be as easy as opting in, and test thoroughly and regularly. Make sure that the consent is working the way you say it's working, and the way that users understand it's going to be working. Because otherwise, if you don't do all of these things, you're going to be opening yourself up to additional risk exposure, which defeats the entire purpose. So Matt, how can companies be putting all of this together and thinking about like whether to get consent or whether to use other tactics?
Yeah, I mean, it kind of goes back to the point I was making is it really is and I know nobody wants to hear this, but it really is a case by case, business by business, kind of situation by situation analysis. And the reason that is because the way that I look at exposure from let's not even use CIPA specifically, but just like wiretap and litigation and this type of technology exposure. It's really the type of information involved, right? So 631, the wiretap 632, which is the unlawful recording, ECPA, which is the federal wiretap statute, that's going to focus on content of communications. So like, the way that it has been described, the way that I describe it, like content is the letter inside the envelope. The stuff on the outside of the envelope, not the content. So it's important to know what information is actually being collected. Another one, and this is really going to tie into what we'll be discussing next, is the manner in which the information is collected. And the reason that's super important is because if you look at these statutes, now I'll set CADAFA kind of off the side and similarly VPPA, but ECPA and CIPA, you're looking at some type of interception. Like interception, let's define that broadly. Courts have defined it broadly, but it really is some third party kind of reaching in and grabbing something before it reaches the end recipient. So if, you know, the theory is for plaintiff's counsel, Matt Pearson's on a website, I click, I search, I do whatever, it's going to the website server at the same time it's going to this third party. That's a quote unquote interception because it hasn't reached the website server yet. That has incredible importance because if there is no interception, there's no 631 claim. There's probably no 638.51 claim. And, you know, 99.9% of the pen register trap and trace claims that we've seen all involve some type of interception. And for 632, there was actually a decision that recently came out of the Northern District from Judge Lynn that basically said it needs to be intercepted as well. It needs to be, I think the language is simultaneous dissemination as opposed to secondhand repetition. About server side, you'll know why that matters. But what information is involved, the way it's being collected, and then ultimately, and this is kind of a backward-looking approach, is you say, okay, I know what information is being collected. I know how the information is being collected. Because of those things, I know the exposure that I face. Therefore, I can tailor my agreements and consents to make sure it covers the information in the manner in which I'm collecting that information. So you kind of need to get to the end to look back and see what consents you need before you do the thing you want to do. It's a tailoring process, but it does require a deeper understanding of what information is being collected, how it's being collected, and then you can turn around and get the consents you need. And like Julie said, getting the consent you need is not just like, hey, do you agree that we can do this? There's a lot of thought that needs to go into it, but you can't have that analysis, you can't have that thought until you know these first 2 points. And Julie actually, I think she's there, but she put this slide together. It's very, very clever. I hadn't thought about it this way, but Julie, maybe you can kind of explain the sliding scale of interception, client side, server side, that kind of stuff.
Yeah, so this is very a simplified version of the way to think about it, but sometimes it helps to visualize it. Essentially, your risk goes up based on the expectation of privacy of your users. So if you have, you know, general retail or news sites, your risk is going to be lower than if you have healthcare, finance, other types of sites where there may be a higher expectation of privacy. And then your risk also goes up based on whether your tags are client side or server side. So your highest risk is if your client side in one of those sensitive or higher expectation of privacy areas. Your risk is the lowest if you are server side and in one of the lower expectation of privacy areas. And of course, there's moderate risk in between. But either way, regardless of the type of content you have, your risk is going to go down if you move server side. And I think that's what we're going to be talking about for the rest of this presentation. The original polls said that not a lot of you were using server side, but let's actually do another poll where we see specifically how familiar this audience is with server side. So how familiar are you with server side tracking specifically as a litigation risk mitigation strategy as opposed to performance or analytics benefits? All right, so while everyone is filling that out, Matt and James, do you want to kind of dive into what server-side tracking is versus client-side?
Sure. We're going to, like I kind of flagged in the beginning, we're going to do it as a question and answer because, you know, I do see that there's a good amount of very familiar on there. I'll tell you, I was not very familiar. And in fact, thinking about this litigation kind of made me familiarize myself with it. But one thing I do want to flag for everybody is when we were talking about a couple slides ago, the interception aspect of CIPA litigation. I want you to really focus on that because that is really the crux of what we're going to be talking about here. I mean, there's a lot more that goes into it, but from a CIPA perspective, I want to make sure everybody's kind of focusing in on the interception. And in fact, when Julia was providing that kind of sliding scale of the more confidential you get, the scarier it gets. Plus, if you add in, and she had it client side, server side, but I would think about it interception, no interception, right? Client side interception and confidential information, real high, not confidential information, no interception, much, much lower. So that's kind of how we're thinking about it. It's not that simple at all, but just want to kind of make sure that that's what we're focused on. But James, why don't you kind of give us an understanding of what is server side and how is it different than client side? And in fact, maybe give us a little background on what we mean when we say client side as well.
Yeah, of course. So it sounds like from the poll, there's a bit of a mix of response. So some of you may already know some of this, some may not. So we'll start with an explanation and a diagram just to talk you through what client side is. So client side means in the user's browser. It means something that's executed as you're browsing on a website. That's happening right there and then. So the left-hand side that you see on the screen here, this is how tracking traditionally works. So the way that a lot of websites out there work, they're using a tool like Google Tag Manager to deploy pixels. So Google, Meta, TikTok, Klaviyo, there's a long list that get deployed. How it works is when you as a consumer go to the website where the jurisdiction requires consent and you've consented, and as was said earlier, the tracking is properly set up in line with the consent has been given and all of the preferences have been set correctly. What then happens is each of the different pixels on the website, so let's say you're working with Google, Meta, TikTok as an example, Google Analytics as well. What happens is directly from the user's browser, so let's say you're shopping, you're on a website, what happens is the request, the event, the action that you do is sent directly to the third party. So that could be to Google, to Meta, etc. That's how client side works. Metrics I've seen a while ago is around 70-80% of websites out there are using client side tracking. So it is what is known as the traditional way to get to track from a website. What server side is effectively is an intermediary step. So what happens is in the browser, rather than sending your interactions to each individual partner, advertiser, and a tool that you may be working with, what happens instead is you have a server. We're not going to get technical because I mentioned the term server, which acts as a stepping stone before you send that data or that data gets sent to any of the partners that that website is working with. So what that means is, we'll use Meta as an example. Rather than the traditional way, the left side of the screen where you visit the website and the request goes directly to Meta, what happens is the server sits in the middle, and that server you control. So what that means is you have full visibility of exactly what is being A, collected from your website, B, sent to the server, and then C, you control exactly what is sent to the partner that you're working with, so Meta in that example. And effectively what that does is it sits as you see on the diagram on the right-hand side, it sits between all of your partners. So you therefore gain visibility, control over exactly what's happening. You can stop things being sent, or you can enrich that data because you have that intermediate, as I described, stepping stone before it gets sent to the third party that you're working with.
So,
sorry.
Yeah. Let me just kind of jump in and pull it back to the legal side of it, and that is when we talked about interception. And I know there was a question in the questions of like, what tool was I using when I went and looked at what Google Analytics it was on the site and the payload. I was using my browser, right? Like I right click inspect, I can see it all. And so can Plaintiffs' Counsel. So there's one aspect of server side, which is, and it's not hiding the ball. It's just now we're not seeing, we being Plaintiffs' Counsel, a laundry list of, third parties. On top of that, the intermediary step that James was referring to, that negates interception. There's no third party stepping in and grabbing it. It's going from the browser to the server and then being passed on to a third party. Now, is there the potential for other claims? Yes, right? Like the information is still being passed on, and you may need to get consent to do that, but it is not a CIPA violation. We have one decision coming out, Rack Room Shoes, where they said there's server side, there's no interception, right? It's going to server and then being passed on. And so that's really what from a litigation side of things, the litigation mitigation side, that's what we're addressing now. Server side has a bunch of other benefits that we'll talk about, but if we're trying to kind of fit this into the legal side of things, that's what we're looking at, right? Like just this shift from client side tag, which is shipping information off to third parties. And oh, by the way, 99.9999% of lawsuits filed thus far are all client side tags. And the one where they focused on server side said it's no CIPA violation. So that's what we're really talking about here. So just to kind of bring it back. Oh, I jumped the gun. I apologize, James.
That's quite all right.
Yeah, go ahead. The question is, Matt, explain, or James, explain what Matt just explained in a much better way.
Yeah, no worries at all. So it is a big point. There's a huge misconception about server side that a lot of people think that it's actually hiding data, which is definitely not the case. If anything, if you compare it to client side, so I know we were talking about the screenshot of the browser a moment ago, where you can see that in the Chrome tools. What happens with the server side is you end up with an audit log. You see exactly what's being sent to the server and exactly where it's going. So with a client side setup, go back to that previous diagram that I showed on the left. As a brand, you have no control, no visibility of what data is being collected and where it's being sent. But what that changes with server side is that what you can no longer necessarily observe from the outside what's happening on the website. And I'll show you in a second what that looks like. But typically what we see is everything moves to a first party data way of being collected from the website. But just because it's moving to first party, you can't necessarily see by inspecting, as we showed in the previous screenshot, once you've moved to server side. The data is still going to all of the partners, but what I just mentioned about the audit logs is the server side, because you own that, it's your server, it gives the website owner the ability to audit every request, like I mentioned, to check whether the consent signals have been passed and whether the user has declined tracking, etc., exactly what has happened, so that if there is a question raised, then there is actually real defense around saying, well, we have a paper trail here of exactly what's happened because we can see exactly what's been collected from our website sent to our server, and then what we've decided based on what's been consent has been given, etc., what is then sent to that third party. So there is a big piece here around element of control, and it's on the website owner to be able to decide what data gets sent elsewhere. So just to not to go too deep into technical, but just to go back to the inspect tool. So I just created a quick diagram just to give you a before and after. So right now what happens on the left-hand side, that is exactly what Matt described, going onto a website, right-click inspect, you can see all of those requests. What happens when a website moves to server side is what you see on the right. So it becomes what I call first party is you see there it says sst.yoursite.com. That's your website. So what it means is the request of the data being tracked from the website isn't being just dispatched directly to a third party. The website owner is taking control of that and then deciding what happens.
This actually might be a good slide to interject and answer one of the questions we have in here. There's a question asking about why the interception in technical terms is occurring in this client side. Can you talk about that, Matt? Why is this client side considered an interception under CIPA?
So the term interception, as we would normally use it, it's probably not occurring on client-side tags. Like it's not what you think. There's not some third party reaching in as a communication is going, grabbing it out of the air, taking it. There's not that kind of interception. But what courts have found is if you are just basically duplicating, so Matt Pearson's on a website, click a button, shoots off to the website server, and then at the same time, I am duplicating and sending a second transmission to a third party, courts have effectively found that is interception. So you kind of have to broaden your thought process about what interception is, but that's what they're saying. And it's like two different communications going at the same time, and they have found that's interception. When you get rid of that second communication, which is what we're discussing here, there's no interception. There can be no interception. So I know it's a little bit confusing and courts have really struggled with this. But for the most part, that's what we're talking about when we say interception.
Great. Sorry to interrupt, James.
No,
it's a good question.
Okay, James, I think we touched on it a bit, but go to a little bit more in depth of, and maybe talk about, some benefits to the client side versus the server side. I know I get some pushback generally when I bring up server side with clients. So let's talk about visibility, control, and the benefits.
Yeah, of course. So we won't go through every tab on this slide, but we'll summarize what happens. So essentially, because you add that intermediary stepping stone that I talked about before, you end up in this world where you have control over what's happening. Control could mean various different things. So what we typically see with the server-side tracking side of things is often brands or website owners look to enrich the data. So I saw a question in the chat earlier about like advertising use cases. So if you're doing advertising with like Google or Meta or another platform, you can enrich data through the server side. You can also do things like offline data. So if you have an offline interaction that happens, so that could be somebody makes a phone call to make a purchase, or they purchase in store, or they do an interaction which isn't happening on the website, then that can also be included as part of that server side setup as well. The other part as well, which we'll come on to talk about in a minute, is we've been talking about the stepping stone piece, but when you have that full visibility, what you're also able to see is exactly what's happening. So you're able to make sure everything's working correctly. Are the consent signals being fired correctly with every event? Is it are the campaigns that I'm running, are they working? So because of this layer that you would put in the middle, it gives you just that element of ability to customize, to change, to make sure everything's working as it should. But most importantly, for the topic of this webinar, is it gives you a proof point. It gives you that audit log and trail of everything that's going on.
We'll jump into this one in a sec, but just from a litigation perspective, I can't tell you how many times I get a lawsuit and I get on the phone with the client and they're like, well, we know we're running it, but I'm not entirely sure what's going or what isn't going and when it was going. This gives up so much more visibility into that, as James has discussed. But James, so we've got the client side, right? Which is what you said, 70, 80%. There's got to be a reason why people are using it. Is there like a degradation in the data being collected from the server side? Is there anything like that? Is it better? What does it do to the data collection?
Yeah, of course. So just because I'm conscious of time, I'll summarize these points quickly. But if you're using Google Analytics, you might have seen over time that the traffic that you see has started to drop down. That's because of a few things that are outside of your control. What we typically see is it's actually like counterintuitively that server side improves the quality of data that's being collected. So the first reason is what I showed on the previous slides with the first party data collection. What happens is some browsers out there, they prevent you from being able to track and collect data if it's in a third party context, meaning that it's not appearing from your website. So browsers like Safari have that restriction in place. If you're not compliant with that, then it will impact your reporting. We have things like ad blockers where they prevent the tracking from working. So it means in some instances, somebody may give consent but not be able to be tracked. What we also see as well, so I'll just jump to the other benefits once you start to recover that data using those 2 points that I've talked about before, which we help overcome. I touched upon this before, but what you typically see as a benefit is when you start to work in a first-party context with the server where you're able to collect and track more data and have more accuracy with what you're collecting, it means you can start to map conversions correctly. So if you're running any paid media activity or you have an email campaign, CRM activity, to make sure that all of the data is being collected correctly and centralized, and then dispatched to all of the tools that you're working with. And then the last point really is around hygiene from a data perspective. So because what we talked about a lot so far is you have control, you can enrich events with your own first party data. So things around customer lifetime value, like any segmentation you're doing, etc., before you then send it on to the other tools that you're working with. So what server-side aims to do, going back to that previous slide with the graph, is to solve those problems that prevent the tracking from actually working and being able to collect data from the website. So I think the next slide.
I think this is probably the biggest question on everybody's mind. You've just told us how great this is. Why are 80% of websites still using client side?
Yeah, so there's the big question about why now. I would say a lot of conversations we have kind of they come from two reasons. So one is awareness. Often brands or website owners don't know that server side exists or necessarily what the benefits are of it. But the second, which I think was a question that came up a moment ago from Donna, is around actually the perceived complexity. So often when you throw around the word server and server side, people think it's quite a technical project. It is if you do it alone, but there are platforms out there like Addingwell, for example, where they make that process really easy for you to adopt. So you don't need the long IT ticket support train to try and jump on that to get that done. It's designed to make things be deployable very quickly and to be able to start getting the benefits of moving to server side. But yeah, for why now? As this webinar is about, we're seeing the stricter data laws. browsers are changing the game all of the time, which impact how you track and collect data. And then a lot of, the ad platforms out there, all of the technology most brands and website owners are using rely on what we call a signal. So that data being tracked from your website to perform as best as possible. So there's a few reasons, but I think the technical hurdle is the biggest. But that's what we aim to simplify.
I mean, I think a lot of the audience on this webinar are legal. And I think the fear, just being legal myself, the fear in their heads is I'm going to take this to the marketing team, to the IT team, to all of our various teams, and they're going to be all upset about it. And it's going to be, one more battle that I have to fight. Is that true? Or is this something that those teams are going to welcome?
I think, especially with what we're about to talk about next, this is where it becomes complementary to each of those teams. So the chart that what Matt talked about earlier with the IT, the marketing, the legal battle, so to speak, between this is what we provide here is designed to help bring everybody on the same page. So obviously from a legal point of view, you want to have visibility so you can ascertain the risk and understand exactly what's happening. From a marketing point of view, you can't turn things off, as Matt said earlier. People want things to work. And then IT, we all have our discussions with IT, so we understand that how things can be sometimes complicated. So this is about simplifying. So really it's about bringing everybody towards the same goal, really. So not sacrificing performance for privacy or privacy performance, but bringing them together.
That's great to
All
hear.
right, James, we've got 3 minutes. I'm going to do the hardest thing possible and shut my mouth and just let you run through the end of it here.
Yeah, of course. So yeah, the last part that we wanted to talk about is, so one of the challenges around what we've talked about today is that audit trail, making sure that everything is working as expected and you're collecting the correct signals. So what we've recently released, so Didomi is the consent management product, Addingwell is the server-side tagging platform. But what we've done is we've actually connected those two platforms together. So the real benefit in this instance is to be able to create that automatic consent analysis where every event that is sent from your website, every item that's collected and sent to the server where consent has been given, you can see in real time whether the signal, the consent has been given and has it been sent correctly. And what that allows you to avoid is where there are potentially misconfigurations. So has something been set up wrong, which is sending data incorrectly to one of our partners, which could expose a risk. And to give you the proactive edge to be checking in real time, rather than finding out through communication that you're in violation, but actually having that preemptive way to check that everything is working as it should be. And what we typically see is this is the before versus after journey. So the left-hand side is the traditional client-side tracking. So you can check and inspect in the browser. When you go just to standard server-side tagging, you don't necessarily have that full visibility that we've been talking about. But what the event consent monitoring offers that Addingwell and Didomi provide is that audit trail, where you can have actual visibility of, did that event get sent, which of your partners received it, was it compliant, and what was the success rate? So actually you have this trail of, once you use the tech, you can actually report back in terms of all of these events have been sent successfully and they have been sent compliantly. So if that question does get raised, you can refer back to that. So just conscious of time, and we have probably a few questions left in the chat. I can hand back over to you guys for the Q&A.
Yeah, so looking at the ones with the threes, Matt, there's one asking, for CIPA website tracking claims, what facts matter most? Tools firing before consent, decline not blocking non-essential tracking, capture of form, search session activity, or vendors receiving or using interaction data?
So I can tell you that the one that matters the least is the last one. CIPA is not really focused on use. We've tried to make this third party, not third party distinction, but it's very, very difficult. Courts have interpreted it as if the third party has the capability, even if you have a contract that says you cannot use this for your own purposes, if the third party has the capability, which everybody has the capability of using the data for their own benefit, they can be considered a third party. The other ones that you mentioned, and I don't have them off the top of my head, but that they all are super important as it relates to what claim is being asserted. So when do these things fire, pre or post consent? That's just a straight up CIPA question. Is the consent mechanism not working correctly? That's a faulty cookie banner class action, which we're seeing more and more and more of. And unfortunately, with those, we're not talking about some unknown and hard to grasp technology where the court's looking at it going like, what are we even talking about? It's just a straight up misrepresentation. You told me you weren't going to do this. I said, okay, please don't. And you did it. So a lot of those claims are surviving past the motion to dismiss. So, I mean, unfortunately, the answer is all of the above except the last one. It's just, you know, understanding what claims could be asserted and trying to address them proactively.
All right. Unfortunately, I think we only had time for one question, but that was a good one. Definitely feel free to reach out to us with additional questions. We're happy to answer them. And again, we'll make the recording available as well. Thank you, everyone, for joining. Have a good rest of your day.
Thank you, everybody.
Thanks, everyone.